Justice Varma case puts spotlight back on judges' appointment system. NJAC vs Collegium explained VP Thankar has said he was bothered by the Justice Varma incident, and things would have been different if the NJAC for judicial appointments had not been struck down by the Supreme Court. The allegations of cash recovery from Delhi High Court's Judge Justice Yashwant Varma's residence has rekindled the debate on the National Judicial Appointments Commission NJAC Act, which was passed by Parliament in 2014, but was struck down by the Supreme Court in 2015. Vice President Jagdeep Thankar, while addressing the Rajya Sabha on Tuesday, said he was bothered by the incident, and referred to the NJAC Act, which was meant to replace the Collegium system. It is not as if executive, judiciary, and legislature are pitted against each other, Thankar remarked. Thankar also held a meeting with floor leaders of parties to discuss the issue. His remarks came on the day a three-member committee was formed by the Supreme Court to inquire into the conduct of Justice Varma. The committee, comprising Chief Justice of Punjab and Haryana High Court Justice Sheel Nagu, Chief Justice of Himachal Pradesh High Court Justice G.S. Sandhawalia, and Justice Anu Sivaraman of Karnataka High Court, reached Justice Varma's Tughlaq Crescent bungalow at around 1:30 p.m. on Tuesday and left after nearly 45 minutes. Nanan Collegium is the system of appointment of judges of the higher judiciary, which evolved through a series of Supreme Court judgments known as judges' cases. The central government has been criticizing the opaque nature of the Collegium system behind a large number of judicial vacancies. The NDA government in 2003 introduced the Constitution 98th Amendment Bill in the Lok Sabha for the formation of the National Judicial Commission NJC. The NJC would be chaired by the CJI, with two of the senior-most judges of the Supreme Court as its members. The Union Law Minister would be a member along with an eminent citizen to be nominated by the President in consultation with the Prime Minister. The NJC would decide the appointment and transfer of judges and probe cases of misconduct by judges, including those from the highest judiciary. Thus, in 2014, the NDA government introduced the National Judicial Appointments Commission NJAC Act to provide the executive branch a significant role in selecting judges for the higher courts. The NJAC bill and the Constitutional Amendment Bill were ratified by 16 Indian state legislatures before being signed by President Pranab Mukherjee on December 31, 2014. The NJAC Act and the Constitutional Amendment Act went into effect on April 13, 2015. But the Supreme Court had in 2015 struck down the JAC Act and the Constitution 99th Amendment Act, 2014, leading to the revival of the Collegium system of existing judges appointing judges to constitutional courts. The bench, headed by the then CJI J.S. Kihar, asserted in the matter of appointment of judges to the higher judiciary, as also in the matter of their transfer, the primacy in the decision-making process inevitably rests with the Chief Justice of India. Nanan the Collegium system, headed by a Chief Justice, decides the appointment and transfer of judges. The forum consists of four senior-most Supreme Court judges as well. The Collegium decides the elevation of Chief Justices, judges of High Court to the Supreme Court, judges of High Courts as Chief Justices and other judges. In case of a difference of opinion, the majority view will prevail. A High Court Collegium consists of the two judges with the next two highest ranks. This Collegium suggests candidates for the High Court positions. A Collegium of the Chief Justice and Supreme Court's two senior-most judges takes the final call. The Supreme Court had recently agreed to hear a petition against the Collegium. The petition sought a new mechanism for the appointment. The matter was mentioned by Advocate Matthews J. Nedumpera before a bench comprising former CJI Chandrachud, Justice Hima Kohli and Justice J.B. Purdiwala. In the plea, Nedumpera and others asked the court to declare Collegium synonym for nepotism and favoritism, as it has resulted in the denial of fair opportunity in the selection and appointment of judges. Nanan Article 124 mentions that the appointment of Supreme Court judges should be made by the President after consultation with such judges of the High Courts and the Supreme Court as the President may deem necessary. The CJI is to be consulted in all appointments, except his or her own. Article 217 deals with the appointment of High Court judges. It says a judge should be appointed by the President after consultation with the CJI and the Governor of the state. The Chief Justice of the High Court concerned too should be consulted. Nanan the Collegium system has its genesis in a series of three judgments, which has been clubbed as the three judges' cases. Following the S.P. Gupta case on December 30, 1981, popularly known as the first judge's case, it was recommended that the executive branch should have the most influence over judicial nominations. 12 years later, in 1993, in the second judge's case, a 9-judge court ruled that the CJI must be given preference in such appointments. In 1998, President K.R. Narayanan issued a presidential reference to the Supreme Court as to what the term consultation really means in Articles 124, 217 and 222. Transfer of HC judges of the Constitution. The question was if the term consultation requires consulting a number of judges in forming the CJI's opinion, or whether the sole opinion of the CJI constituted the meaning of the articles. In reply, the Supreme Court laid down 9 guidelines for the functioning of the quorum for appointments transfers. This came to be the present form of the Collegium. Besides, the third judge's case judgment dated October 28, 1998, written by Justice S.P. Barucha as the head of the 9-judge bench, strongly reinforced the concept of a primacy of the highest judiciary over the executive. Nan.